Be seated. The record will show the presence of the jury, the defendant, and all counsel. Ladies and gentlemen, as you know, juror number 11 is ill. The court has excused him from further participation in this trial. Mr. Martinez, you may continue.
Ma'am, you indicated a number of things in response to questions by the jury involving Mr. Alexander, didn't you?
Yes.
You indicated, for example, that he irritated women. Do you remember testifying to that yesterday?
I don't remember saying he irritated women.
So if the record reflects that, would you have a quibble with what the record says?
No, I wouldn't.
And you also indicated that he played women. Do you remember saying that?
Yes, I remember saying that.
The other thing that you indicated was that you wished that you could get a complete story from Mr. Alexander, correct?
That would be good, yes.
No, you said you wish that you could get a complete story from Mr. Alexander so that there could be a complete evaluation, correct?
Objection is to the last part of the question.
Mischaracterizes her testimony.
Answer.
I don't recall saying so I could get a complete evaluation.
So you're saying that without Mr. Alexander's input, you're getting a complete evaluation in this case, right?
I'm saying I have enough information to look at domestic violence.
And one of the things that we looked at was your continuum. Do you remember that?
Yes, I do.
And you used different words for the people that were involved. And in this case, you told us previously that you believed that Mr. Alexander was the perpetrator, correct?
I believe that I said I believed he was perpetrating domestic violence, yes.
So if he's perpetrating domestic violence, he's the perpetrator of the domestic violence, correct?
Correct.
And that he perpetuated that on the defendant, correct?
Yes.
What was the new term that is not used for victim, that is now used in vogue? What's that called?
Survivor.
And so you indicated that Mr. Alexander was the perpetrator and that Ms. Arias was the survivor, correct?
I don't recall if I said exactly that, but...
Judge, may we approach?
may continue.
Ma'am, as part of this evaluation process that you were hired to do, you were paid to do this process, right?
I was paid to do this
Right, I think you
process.
said it was $2.50 an hour, correct?
Objection beyond scope.
Overruled.
Correct?
Correct.
And to testify is $300 an hour, correct?
To testify is $300 an hour.
Now, ma'am, as part of this process and in reaching your opinion about the domestic violence in this case, isn't it true that you evaluated Mr. Alexander?
I looked at Mr. Alexander's behavior. So did I diagnose Mr. Alexander?
I'm
No,
not-
I didn't.
I'm not asking if you diagnosed it.
Okay.
I'm asking if you evaluated him such that whatever decision you made, you incorporated it in your opinion in this case.
I evaluated his behavior and I looked at his background to help me assess this case.
And so you evaluated the behavior of a human being, correct?
Yes, he's a human being.
And after the evaluation of this behavior, you reached certain conclusions, right?
Correct.
One of the conclusions that you reached in evaluating his behavior was that he was a liar, right?
I reached the opinion that he told lies.
Well,
No, I didn't call him a liar. I said he told lies to people, and those were in his words. Those were in his communications with other people, that he professed to being a virgin, and that was a lie.
so people who tell lies are liars, aren't they, by definition?
Not everybody who tells lies is a perpetual liar, but he had a habit of telling a lie.
Right.
Yes.
No one's saying perpetual. We're saying liar. You added the word perpetual to this, didn't you, just now?
Yes, I did.
My question is, an individual who has a pattern of lying, which is what you said about Mr. Alexander, that is a liar, correct?
Correct.
Vague.
Timeline of when the person's a liar.
Sustained.
In this case, ma'am, whatever time frame you used when you testified and spoke to the jury, you indicated that Mr. Alexander had a pattern of lying, right?
Correct.
And you just said that anybody who has a pattern of lying is a liar, correct?
Objection. Foundation.
Overruled. I said that Mr. Alexander lied. Yes.
And he had a pattern in addition to that, right?
Correct.
And anybody who has a pattern is a liar, correct? Yes or no?
Yes.
The other thing that you told us about Mr. Alexander is that he escalated these arguments between him and the defendant, right?
I said that he had a pattern of escalating.
All right, and you called them rants, correct?
Yes.
And you called them rants based on the written word, correct?
Correct.
You couldn't see, or you have no way of knowing what his demeanor was when he was writing that, do you?
No, I don't.
And in fact, you've told us that 90% of all communication in this particular area is nonverbal, right?
You can read into a rant.
I know that you can read into a rant, but I'm asking you something different. Isn't it true that you testified to this jury that 90% of all communication in clinical settings is nonverbal? Yes or no?
Face-to-face communication is what I said. When we are face-to-face, about 90% of our communication, and that's a saying in the field.
And it's a saying that you advocated when you told us about it, right?
Objection beyond scope.
It's already been clarified.
Right?
Right.
In, for example, a text message, like the text messages that were referenced as part of the questions from the jurors. Isn't it true that in those, you don't even get to see the interaction of the two people, do you?
In the text messages?
Yeah.
You get to hear the communication between the two. You get to see it on the page.
Right. You get to see words going across the page. That's what you get, right?
Correct.
You don't get to see or hear inflection, do you?
I think it would be hard or difficult to think that somebody was in a really good mood calling somebody those names.
Am I asking you whether somebody was in a good mood or not?
I think...
Yes or no? Am I asking you that?
No, you're not asking me that.
I'm asking you about the limitations involved in a text message. You understand that there are limitations about a text message, right?
Objection beyond scope.
Overruled.
Right?
I suppose there are limitations as there are limitations between the spoken word.
We're not talking about the spoken word. We're talking about text messages. Do you understand that?
I understand you're talking
I
about
want to
limitations.
talk to you about text messages.
Objection, Judge.
Only one person speaking at a time. He's interrupting her answer.
Yes, that is correct. One at a time. Mr. Martinez, let her finish her response or ask the court to find her non-responsive.
Are you saying that you are as effective in conducting an evaluation, such as in this case, when you have the person, a clinical interview, and for one person, and then with regard to the other person, all you have is the written word. You're saying that's just as good, right?
I'm saying that in many cases that's all we have.
I'm not asking you if that's all you have, am I?
You're asking me what's more effective, and it depends
No.
on the situation, Mr. Martinez. That I could be having a clinical interview with somebody who is totally, misrepresenting themselves. I rely on the consistency of the information that I have, and if there's consistency across sources, it makes a difference.
Are you done?
Yes,
your
I
answer?
am. Yes, I am.
My question is different than that. I'm asking you to think of a situation where you have a conversation with an individual. I want you to compare that clinical interview to the circumstance where all you have is a text message. Are you saying that both of them are equal in terms of making an evaluation of what the person is saying, thinking, feeling at the time that the statements are made?
I'm saying they're different.
I'm asking you which one is better. That's what I'm asking you.
I'm saying that sometimes one is better than the other, and I don't know what is better all of the time, that I have to look at what I've got. And if I get a clinical interview, that's a good thing. But I've had clinical interviews, for instance, between people who come into my men's group and their partners, and they're very different interviews, and the information is very different. So you can't always say one is better than the other. I can't always say that.
Doesn't that go contrary to what you just told the jury earlier today, what you just said now?
I said I would like to have had an interview with Mr. Alexander,
Right.
and I would have.
And that means that by you saying that you would have wanted the interview, that means that you believe that it is better to have spoken to Mr. Alexander as part of this evaluation than to just look, for example, at text messages, right?
You want me to say it's better. I'm not saying it's better. I'm saying there's more information. I get different information. I'm not saying I didn't have enough information.
I'm not asking you if you had more information. You're saying then that it is not better to have the other person involved in this relationship, to talk to them, than as opposed to a text message? Is that what you're saying?
Objection, asked and answered beyond the scope is being clarified.
Overruled.
I'm not saying that it's better, and I'm not saying that it's worse. I'm saying that comparatively, it would have been good to be able to compare the two stories. What I have is information that I think allows me to compare the two stories. I always want more information if I can get it, Mr. Martinez.
Ma'am, one of the things that you told us was that going into this particular evaluation was that you believe the defendant based on the readings, correct?
Based on which readings?
Whatever readings you made, I don't know.
Objection,
That-
this characterizes her testimony as
Going into this evaluation, she believed her.
Overruled.
I didn't go into this evaluation believing Miss Arias. I went into this evaluation, as I hope everybody does, going in with an open mind and looking at what's there and what I can base my opinions on.
And then you sat and you spoke to her for 44 hours, correct?
different periods of time. Yes, I did.
And during that time, there was other materials that was provided to you, right?
Correct.
And nowhere during that time did you speak to Mr. Alexander, correct?
Correct.
Judge, and asked me to answer.
Distinct.
And you would agree, ma'am, that your evaluation in this particular case is defective because you only spoke to the defendant who has lied and not to Mr. Alexander.
I would disagree totally with your
Thank you.
conclusion that I'm
Thank you.
defective.
I don't have anything else.
Can we approach her?
You may. Ladies and gentlemen, as always, thank you for your patience. We were talking about scheduling issues. On Monday, please be back at 1:30, but please have your cell phones with you or be near a phone where we can reach you on Monday morning around 10 o'clock. As of right now, plan to be here at 1:30 on Monday. Are there any questions? I see there is a question in the box. Council, please approach. One additional question from the jury. Was Ms. Arias' story from October 2011 through November 2011 consistent with the story as we know it today?
I didn't hear her testimony, so it was consistent with what I knew from October 11. From the time that I started interviewing her, her story was consistent with me, but I wasn't privy to her testimony.
Any other questions from the jury? Any follow-up? Ms. Wilmot?
No, Your Honor.
Mr. Martinez?
When you say her story was consistent, the story included the fact that, as you related to us, that the shooting occurred in the closet, correct?
That was not her story. That was a mistake that I made in writing it down. I looked at some other reports, and there was a report. I have different notes, Mr. Martinez, and so on one of the notes I may make no mention whatsoever of the closet, and I made notes from what other reporters said, I believe Dr. Samuels or Dr. DeMarte, and I wrote those notes down too. So I misspoke on that, but I didn't, from my interview with Ms. Arias, have that the shooting occurred in the closet.
You did, when you spoke to the prosecutor back in November 2012, you did tell him that the shooting occurred in the closet, correct?
I did.
And
I misspoke. I took two different reports, as I said.
the answer is yes.
Okay.
No, is that yes?
Yes.
Thank you.
All right, ladies and gentlemen, Monday, 1:30. Please have a nice weekend. Remember the admonition.
Your Honor.
Sit right there. So the jury has left the courtroom. Please be seated. Ms. LaViolette, we will need you to return on Tuesday to complete your testimony unless I release you from your subpoena prior to that time. There is another issue that I think you were aware of the additional issue. So we will need you to be back here on Tuesday. With regard to the time, I know that you haven't I had some other issues, but this is a priority. So because you cannot be here on Monday, you need to be here on Tuesday. So it's either Monday or Tuesday. I'll allow you to decide which you'd prefer, which date you'd prefer to come back.
And I may have follow-up tests that
Yes,
I can do.
Ms. Lila, don't tell me about your personal issues. Here's my concern. My concern is that we will have a conversation on Monday on the record after everyone has had an opportunity to follow up on the issue we've discussed. And at that time, I will hear anything else. You will have made preparations and we can talk about it at that time. All right, but plan to be back here on Tuesday. As of right now, you are still under subpoena. Counsel, you may. All right, on Monday at 11 o'clock, Ms. Wong, you are in the back of the courtroom, is that correct?
Yes, I am, Your Honor.
Will you be here to testify?
If you order me to, so.
All right, I guess then I will order you to be here at 11 o'clock to testify. I understand that you have an attorney. If there is any issue, he can raise that. We will be here starting at 9:30 on Monday. All right? Anything else, council?
No, thank you.
Thank you. Have a nice weekend.